Sir, our government is very keen that India should become a big hub of domestic and international arbitration. Sir, this New Delhi Arbitration Center is basically designed to give the International Arbitration Center an eminent institution of global importance. Sir, I want to just convey to this House, sir, government have spent 30 crores and since 1995, only 55 arbitrations have taken place. No work was going on. Therefore, the Sri Krishna Committee was set up, an eminent Supreme Court judge who has given a recommendation that this center must be taken over by the government to make it an eminent center of global arbitration. And sir, they have also recommended that proper other changes in the arbitration law be made. So with that light we came, we had to fast track, convey a good sentiment to the global community, to the Indian community, and that we are very serious about fast tracking this arbitration proceeding. Therefore we have come, sir.
Mr. Minister, you please move the bill for consideration and passing.
Sir, I move the bill for consideration and passing.
Manya Mantri.
Sir, I am really grateful that the debate rose to great heights and we all notice extraordinary unanimity, even by Honorable Prem Chandran ji. For the first time I am seeing her supporting a bill, except the NJSC, which I noticed in 2014. Good. Sir, I am not taking the names of all, sir. The quality of debate was very good, with the Adhir Babu in his own inimitable style also supported. Ordinance, I will reply later on. Meenakshi and Pinaki ji rose to great height. Very Sogat Babu, I don't see him. Yes, with your earthy common sense, you added great value to the debate. Sir, I would, very outset, let me highlight why we had to come with this. India is becoming a big investment center, the fastest growing economy of the world. Alternative dispute redressal is an important component of this process. There was a conference where the Honorable Chief Justice was present, the Prime Minister was present, as the Law Minister I was present, and a conscious decision was taken that India must strive to become a global hub of domestic and international arbitration. I was handling this portfolio then. Then I decided we should not go piecemeal. We need to have a comprehensive review of the entire ecosystem, what is required to be done. And thereafter we came with suggestion of making Justice Sri Krishna, a very retired distinguished judge of the Supreme Court, to give us a report both on the roadmap and the legal architecture which is required to be improved upon. And we had some of the finest minds of India as a part of that committee, including Mr. Venugopal, the Attorney General. Some eminent arbitrators were there, practicing from Bombay, the law firms were there. They had proper feedback from all over the country. And they said two things. First was, please make this center as a center of international eminence. Second, make India a hub of institutional arbitration. Because globally, I would like to inform this Honorable House that institutional arbitration has become the order of the day. So that parties can go, even in India, 35 institutions have started working. London and Singapore have become important well-known centers. But to become a global hub of institutional arbitration, we must have a mechanism in place which can properly accredit the institutions. Which institutions doing well, the arbitrators are good or of good quality. And the subsequent law which also lapsed, which Mr. Sashi Tharoor talked about, contains the entire mechanism. There shall be a proper Arbitration Council of India, headed by a retired Supreme Court Chief Justice, consisting of eminent people, which shall accredit institutions doing arbitration, arbitrators disposing of cases, and they will individually give a report, and their accreditation would be a benchmark for their efficacy, for the global clients also to see. Sir, before I come to the other points, I want to make one larger observation. Pinaki Babu, my good friend, mentioned about his Singapore experience. But of late we are witnessing a new kind of imperialism in arbitration. Queen's Counsel barristers becoming the arbitrators everywhere, as if, with great respect, they're the last word. And sir, bilateral investment treaty, what is happening? I attended certain international conferences. South Africa has walked out, you know it very well. Mexico has walked out, Brazil has walked out. Why? Because these arbitration proceedings are imposing heavy damages upon small countries, which we can't afford. For instance, in one case, sir, only 100 million was to be invested. They invested 5 million. They came with a grievance that government is not giving us support, give us damages, and they were given about 30 to 40 million damages. Then all the small countries said, this is too skewed a proceeding in favor of big power. And sir, I'm sorry to say, but I'll have to say, none of these bilateral investment treaty proceedings ever gave any big award against any big American or European companies. I'm sorry to say that. When I studied, sir, I have taken upon myself in the national fora, international fora, I have been speaking that this kind of new imperialism in arbitration will not be acceptable. India has very good arbitrators, very good judges, very good lawyers. That was the larger issue, Sagar Babu, I want to tell you, which was working in my mind when I wanted India to become a good center of arbitration disposal mechanisms. Therefore, first of all, I would like Adhir Babu also to tell you that you talked about unilateral model. Unilateral model is a global model, UN trade approved, whereupon all the countries of the world have remodeled their arbitration laws. But in the light of the Sri Krishna recommendation, we need to further reinforce our arbitration proceeding. So kindly wait, that law will also come very soon, I want to assure. Now, sir, as far as specific concerns in the present proceedings are concerned, sir, let me tell you, to put the record straight. The government has given 30 crore to this international arbitration bid, 30 crore, including land. Sir, just now I asked my staff to tell me the exact number. Since 95 till last year end, Babu, only 55 cases were referred to them. 44 5 were disposed of, 10 pending, and only 4 international arbitration. When I was reviewing, 700 members are there. This seminar, that seminar, Delhi to Hyderabad, Hyderabad to Bombay, plane fare, all fare, going. The core work was missing completely. Mr. Mishra, you talked about why it would happen. That is a sensitive question. I regret to tell you, if a law minister seeks to make it a private property, then what will happen? I'm sorry to say that. No, take it. Let us leave it there. I think I have given enough indications. And I regret to say, in 10 years, some action ought to have been taken, which was not taken. Let's leave it there. Now, sir, what we are doing? First, see the professional part of it. The government does not have a power. The government will appoint the head of a retired Supreme Court judge or retired High Court judge in consultation with the Chief Justice of India. That's number one. 2 eminent arbitrators who have experience in that. Third, the law secretary and someone from finance will be there. Now, but this is the composition of the body, sir. But I'm really appreciate what Meenakshi Lekhi rightly pointed out. The rub of the matter is 28. The center shall establish a chamber of arbitration which shall impanel arbitrators and also scrutinize the application for admission in the panel of reputed arbitrators to maintain a permanent panel of arbitrators. If you ask me, sir, what is the harm? Let there be judges. Let there be a retired Secretary Finance Government of India. Or let there be a top executive of a good international firm working in India. All this can be kept. Now I know, sir, handling the IT and communication portfolio, that now serious technical issues will come to the arbitration proceeding. What is the harm if some top IT giant experts are also as a part of panel? So these liberty must be given to the arbitration body to keep a panel of eminent arbitrators. And I think the House is completely right, sir. The success of this institution will depend as to what kind of arbitrators they keep. And speaking for myself, I want to give the assurance to this House, our government's concern is very, very clear and categorical. We really want this institution to emerge as a global hub of international and domestic arbitration. The autonomy, the flexibility, everything would have to be there. Now, Mr. Tharoor specifically talked about, sir, Section 11. I think if you read it, the direction of the government is only till the assets are taken over by the custodian, not beyond that. Because there is a transitory phase, sir. And, sir, why we have done like this, sir? We are not touching the society which was running the institution. Let the society remain with itself. Only the asset part we are taking over, as in the case of Asia Society or Auroville Society or Sapru House, you know that, India International Affairs, the same model we have applied, whereby we are only taking over the asset to make it more professional, sir. This 30 crore have gone since 95 till now. Now, Nishikant ji is absolutely right. Yeah. If you value this property today, it will be worth hundreds of crores. Yes. And what for it was used, beyond this I have already given enough indication. I regret to say, sir, this body could have evolved as a beacon of India's arbitration proceeding. I regret to say what happened, at least I say the more. Now, sir, what we have done, sir, questions were asked. Yes, arbitration part I explained. Sir, we have, in enforcing contract, the biggest problem was a Specific Relief Act, where damage was the norm, performance of contract was the exception. We changed that also, that now a party in the wake of any recalcitrant party can get the contract executed by third party and recover the amount from him. Now the damage is the exception. That is commercial court, sir. The system giving the ease of doing business benchmark set. You have 1 crore, 2 crore norms you have played. What about small commercial disputes? Then now we have also reduced that to 3 lakhs. And we have set up good commercial courts all over the country, including in Delhi and Mumbai, which are functioning. But what is important I would like to share with this House, sir, we have come with a very robust mediation law. In commercial court, no one can go to the court straight away, unless you need injunction, etc. First, you have to go to the mediation. And with a defined frame, mediation will have to be decided. And the mediation is not able to give the right results, then dispute will go to the court. And that we have done under the aegis of the Delhi High Court, the Bombay High Court, and the Supreme Court, and now it has become a very robust tool. Now, sir, some questions were asked. What about if the arbitrators also delay? The question is right. And therefore, the subsequent 1996 amendment, which we are going to bring again, which was passed by this House and lapsed again in Lok Sabha because of pending there. We are framing a time frame for disposal of cases by the arbitrator. And I am very clear, let me tell this House, sir, that when the rules will be free, we'll bring it very soon. Sir, just a minute. And when the rules will be framed, sir, I will insist that all the institutions must keep one fact in mind. ये आर्बिट्रेटर साहब ने पिछला फैसला कितने दिन में किया था, उनका ये साइड पर रहना चाहिए. इसलिए आगे से इनको रखने के पहले इनकी इस कुंडली को देख लिया जाए कि ये कितने में फैसला करते हैं. आई एम वेरी क्लियर अबाउट इट, बिकॉज इफ वी हैव टू रियली डेवलप इंडिया एज a center of good global international arbitration, these do's and don'ts will have to be done. Sir, what is transparency issue was raised by Mr. Tharoor. The regulations are very clear that these aspects will have to be done. Mr. Tharoor, today I was a little, I don't know what should I say. At one point you say you are bypassing Parliament. And when we are saying the rules and regulations shall be placed before the Parliament, you have a problem. No, just a minute. The framing will not be done by us. The framing will be done by them. They will be placed here only for the parliamentary scrutiny. If you have any questions to ask, suggestion to give, so that they can take corrective measures subsequently. It is always in most of these are brought. They should not make an issue about it. Now, sir, today I have to make one appeal, sir, because I think I have addressed nearly ordinance part. I will come to the last. I'll explain that, sir. But today, when we are considering to make New Delhi Center as a center of global eminence, sir, and sir, what is my vision, sir? The government's vision, the vision of all of us. India must have a very robust bar of young lawyers who are practicing arbitration. It is a great avenue for us. India must have good teachers teaching arbitration laws in National Law School and other schools. And most important, India must have a robust set of good arbitrators, trusted, honest, transparent, and disposing expeditiously. Today, taking the benefit of this great sacred floor of the Parliament, sir, I would like to appeal to all the arbitrators in India that if India has to emerge as a global center of eminence, we have to be honest, we have to be expeditious, and we must need to understand the changing profile of India. So my two friends who have personal experiences have conveyed a concern, and that concern I take on board. अब सर ओवैसी साहब की परेशानी है कि बाकी कानून में क्या कर रहे हैं, तो बाकी कानून में बदलाव कर रहे हैं, काफी कुछ किया है और करने की जरूरत है, मिलकर करेंगे। लेकिन अगर एक अच्छा काम हो रहा है, उस अच्छे काम को अपने चिंताओं के कारण रोकने की कोशिश करना, मुझे लगता है हमारी सरकार से आपकी नाइत्तेफाकी मुझे मालूम है ओवैसी साहब, लेकिन कभी कभी कुछ अच्छा ही देख लिया कीजिए, तो बड़ी मेहरबानी। और ये मुझे बड़ा अजूबा लगा कि पूरा हाउस आज इस बिल के साथ है, यहां भी आपकी नाइत्तेफाकी है, कभी तो कभी मुस्कुरा दिया कीजिए तो अच्छा रहेगा सर। सर मैं क्या कहूं सर, इस तूफान की आशंका में वो और उनकी सियासत करने वाले कितने सालों से बैठे हुए हैं। एक तूफान आएगा, हम खड़ी रहेंगे और पूरी गंगा हमारे साथ चलती है, तो हम क्या बताएं सर, छोड़ा जाए सर। सर, now the concluding part which I will say, sir, I am very happy. I wish to really compliment all the members of this house who have so wholeheartedly supported it, sir. Let this house today take a resolve. This one bill is being passed today, and I promise Mr. Mishra, Meenakshi, and Mr. Tarur, I am going to bring the other bill very soon. Now, these two platforms will surely give a big support and strength to India's alternative disposal mechanism system, and surely the global community of investors, clients, professionals are also hearing that today India's parliament, the Lok Sabha, has risen in support of India becoming a center of arbitration. Thank you, sir.
मंत्री अब ये प्रस्ताव करें कि विधेयक को पारित किया जाए।
प्रस्ताव करता हूं कि सदन इस विधेयक को पारित करे।
प्रश्न है कि विधेयक को पारित किया जाए। जो सदस्य इसके पक्ष में हाँ कहें, जो सदस्य विरोध में ना कहें। मेरे विचार में निर्णय हाँ वालों के पक्ष में हुआ है, हाँ वालों के पक्ष में हुआ है। प्रस्ताव स्वीकृत हुआ और विधेयक पारित हुआ।